appeal hearing in the matter of C82-2017, David Lawrence Haigh versus GFH Capital Limited, before Chief Justice Michael Hwang, Justice Judith, Prakash, and His Excellency Justice Omar. The appellant is appearing in person by way of telephone. The respondent is represented by Brian Haigh. Lead counsel is Andrew Omar, assisted by Robert Judith.
Good morning, everyone. Mr. Haigh, can you hear me? This is Michael Hwang speaking.
I can hear you. It's quiet, right? Just about making that.
Counsel, would you introduce yourselves, please?
Yes. All of One second. For the respondents.
Sorry, Mr. Haigh, just hang on a minute.
For the respondents, Your Honors, my name is Andrew Bodnar. I'm assisted by Mr. Judith. I believe the first order of business is an application by Mr. Haigh filed last night. I hope that Mr. Haigh can hear me speak.
Mr. Haigh, could you hear Mr. Bodnar just now?
I'm hardly hearing. I'm very difficult to hear you.
We are adjusting the volume now.
So I don't hear that much.
Yeah, just give us 1 second. Okay, is that better?
It is now, but it comes and goes. So the feedback, I don't know if you can hear it, but it's reaching noisy when it's...
Yeah, I think we've now resolved that.
Yeah, well, I can hear you fine now.
Okay.
Mr. Haigh, this morning you have filed an application which sets out the...
Sorry, I'm still conscious. I was trying to do that, but I can't hear very loudly.
Let me try again. Mr. Haigh, am I coming through clearly now?
Yeah, that's better.
Yes. Mr. Haigh, you have filed an application, which I believe the other side has got, an application in the CFI case, but I think we can treat it as, well, we'll see how we treat it in a minute. But can I confirm that Brian Cave is in possession of that application filed by Mr. Haigh?
Your Honor, yes.
I know that.
Yes, we are.
Mr. Haigh,
Really bad feedback again. I don't think you just heard that. If that's come across it, I couldn't hear. I just got very bad feedback noise.
Yes.
yes, we're still adjusting it, but I will tell you that Brian Cave confirmed that they have received that application, which bears the date of 13th of September. So, would you like to proceed, Mr. Haigh, and address the orders that you want in this application?
First of all, in relation to the application, it was filed late yesterday due to an error with the DIT court's online system, of which I believe Ms. Patton is aware. So it prevented me from filing it on the Court of Appeal system. The only way that I could file it after experimenting for about 2 hours was to file it through the CFI case, which is why it's been filed that way. Now, what that meant is that whilst the application was intended to be filed early in the afternoon, it was also filed very late due to mistakes on the part of the DIT and errors in the system. So that's point one. that's why as we began, you said that it was under GFH, but it was that's why. Now, before I go on, I sent across a letter from my doctor yesterday, I believe, to the registry, and that's also included in the pack that I sent across. Have the justices had time to look at that letter?
Yes, this is the one from your GP, am I right?
It's the one from my consultant psychiatrist, so not my GP, but the doctor that's in charge of my care for the treatment post the torture I was receiving in the UAE.
No, I have seen that one as well. There is a very short one, which I think is for some statutory purpose. That was, I think, signed by your GP, which gave you a medical certificate for 3 months. I've also seen the longer one from the psychiatrist, yes.
Okay, so in short, as you'll see from the summary of the letter, my psychiatrist has advised that I don't take part in this discussion being a hearing with parties that I hold responsible for the torture of me, or the human trafficking of me. As you'll be aware, I spent 5.5 months in hospitals in the last 1.5 years. I am, even as I speak today, exceptionally unwell and suffering from the symptoms set out in that letter. Now, that means that the actual application itself and myself in that, I'm simply not fit to continue in this hearing. So I think the medical advice and evidence is there. So I would ask you first, before we go any further, to consider that, please.
It will be taken into account, yes. Please carry on.
I think that the point in the letter is that I cannot carry on. Because I've been advised that I can't carry on, risks my health to do so, and I'm not fit to do so, which is why there's an application to adjourn in. So I was thought that it is not suitable to consider that at the beginning to find out whether you intend to go on or not. Because obviously, as I've been instructed by my doctor not to take part in this, and having spent 5.5 months trying to get better, I don't want to risk my recovery for something that could be easily adjourned.
We are only at the moment dealing with your application to adjourn. So that's on the table and nothing else for the moment. Just deal with that first, and then we'll worry about the rest later.
But I understand. Sorry, what do I call you? I don't actually know. I'm not litigated, so...
Oh, just call me Chief Justice or Your Honour.
Okay, all right. So my point is that by going through the application, the full application is going to take time, and that is going to damage me and cause me suffering going through that. That is clear, I think, from the evidence that you've got before you. So my point is that by being forced to go through the application, that is going to cause me damage and defeats the purpose of the adjournment application. The purpose is that damage is caused to me.
You are saying that you want an adjournment and you can't make the application for the adjournment because you're too ill to do so.
This is what I have been advised by my doctor, and that's what's set out in that letter, that I am too ill to go through with the hearing today.
Just on the application to adjourn?
I'm sorry, I don't understand.
Are you too ill just to make an application to adjourn orally?
I don't know how long an application to adjourn orally takes. I've obviously written the lengthy statement, and my intention would be that if I were to do that, is that I would go through each part of my witness statement, bearing in mind that the justices haven't had much time to look at it. So I don't know how long that will take. You know, if it takes 5 minutes, I've already been talking for 5 minutes. But if it takes, a long time, and it involves discussion and argument with those responsible for torture, this is something that I have been categorically advised not to enter into because it will result in no doubt the emergency call potentially and return to hospital. But having spent 5.5 months now, I don't want to do that.
Mr. Haigh, actually your written application is very fulsome. I think we understand quite well what you're saying and why you're saying it. The facility of giving you an opportunity to address us orally is entirely an optional extra. You don't have to address us at all, and you don't have to feel obliged that you need to take us through all of your written submissions. In the Court of Appeal, mainly we're working on the briefs in any event. This is a relatively straightforward matter. You've explained your situation, I believe, very well. You've given us copies of supporting evidence from your doctors. So I think actually we are in a position not to require a lot of oral assistance from you, and you are at liberty to speak for as long as you feel able to, but frankly I don't think you need to say very much more. We know what you want to say, and in fact we know what you have said, and you make your points quite clearly and I believe quite fully.
And like I said, as you've seen in here, you have better judgment, so you know what symptoms, and at this point in time I'm going through. Now, I'm going to make a full application. I would want to take the justices through it orally, and I would have to do that, and I would force to, because obviously the adjournment to me is critical. That's point one. So I would then have to take the court through that application orally in the hope that there would not be any need for me to have any form of discussion with the parties responsible for torturing me.
On that part, I think that's quite clear. The way that arguments before the court are conducted is that each side will address the court individually. There's no discussion between the parties, either themselves or through counsel. So each of you will address the court in turn, and you have an opportunity to respond if you want to. You don't have to.
I understand, but my point remains that in that exercise, listening to people that were involved in working in human trafficking into Dubai, and then ensuring that I was also locked up for 22 months and being tortured and raped, listening to them set that out in Europe, which I have to listen to and would need to respond to, is what my doctor said will cause me significant harm. And that's why I want to adjourn. So this is my problem. If I carry on, then if I have an adjournment application which is detailed, I would want to present that properly. And I'm not, as we see today, able to do that properly because of the symptoms that I've had. That's even an adjournment application. So because I think it's for me very, very important that the appeal hearing is adjourned, because clearly I'm unwell and I have no lawyers, and for all the reasons that I set out in the adjournment application. So I would take your guidance on how we proceed from here, and hope that you understand my point.
I suggest for the moment we will hear from the other side as to what the response is to that immediate application you're making. And as I understand it, what you're saying is that you want to apply for an adjournment. You feel that you need to make oral submissions at length, but you feel unable to participate fully in the process because you are unable to endure listening to an argument from the other side that might say things which will upset you. and lead to complications with your health.
I don't think the word upset the Chief Justice is fair. It's not just upset, it's 5.5 months, 5 months in and out of hospitals. So it's not about being upset. It's about a illness called post-traumatic stress disorder. So it's far more than being upset. Being upset is something that I can deal with. But being damaged is something that I can't deal with.
Yes, I understand. So I believe, subject to that clarification from you, I understand what you're saying. Let me just hear from the other side. If you are not happy with hearing anything, you are at liberty to mute your phone and we will call you back after they're finished. But you are certainly entitled to listen to what they say. If you choose to exercise not to hear what they say, that's fine, that's up to you.
I will listen until something comes up that causes me concern, and then I will necessarily use.
Thank you. Okay, Mr. Bodma?
Your Honour,
Let's have a testing session first. Let's make sure that Mr. Haigh can hear you, Mr. Bodma.
Mr. Haigh, can you hear me as I speak? Mr. Haigh?
Okay.
Mr. Haigh?
Yes, I can hear you.
Yes. Thank you very much.
So,
Yes. Thank you very much, Mr. Haigh. Your Honours, if I understand Mr. Haigh's instant application correctly, he essentially wishes to apply to adjourn his application to adjourn. In short, he is saying that he's simply unable to progress this case in any way so long as GFH Capital remains a party to the case, or until his mental health improves. Now, as to the former, GFH Capital is necessarily going to remain a party to this case until it concludes. If what Mr. Haigh is suggesting is that this court should simply stay these proceedings indefinitely until and unless a doctor certifies that he will no longer suffer any form of stress.
sorry, I'm here. I'm getting someone's opening and closing files, and I'm getting a lot of noise.
If Mr. Haigh is suggesting that this court should stay these proceedings indefinitely and await a doctor's certificate that he now considers himself fit to proceed with the case, then of course we resist that application. Mr. Haigh has raised this issue at regular intervals, and on each occasion, a few days before, a substantive hearing was due in the case against him. If Mr. Haigh is saying that the court should adjourn his application to adjourn for 2 months in the hope that by then he will be well enough to make a substantive application to adjourn the appeal, then in my submission, his actions last night establish why it would not be an appropriate course to follow. And the reason I say that is that Mr. Haigh was well enough to prepare a witness statement running to 52 pages. he was well enough to collate an exhibit. And he was well enough to draft an order which has, if Your Honour gives me a moment, it's 11 paragraphs and seeks 11 heads of relief. Having drafted it, this morning he says he is not, it would be extraordinarily traumatic for him and risk a trip to hospital if he were to move it. In short, with respect to Mr. Haigh, he is simply saying he is not prepared to progress his own appeal. He refers to having been in and out of hospital. Your Honours will recall that Your Honour the Chief Justice granted permission, exceptionally in this case, because of its very particular circumstance. The appeal is listed today for two reasons. Firstly, the availability of Mr. Jones, Queen's Counsel, who has exited the case in the interim. And secondly, to enable Mr. Haigh to go to hospital for a period of 2 months, after which it was suggested could be expected that his treatment would be complete and he would be recovered sufficiently to progress this case. But for those two matters, this appeal would have been listed in May. Your Honours have the judgment of this court, differently constituted, but again presided over by Your Honour the Chief Justice, dated the 28th of February. And I know that Your Honours will have refreshed him, and I know that Justice Omar was also part of that court. And Your Honours will recall the findings made as to how Mr. Haigh and Keystone Law had chosen to progress matters during the course of 2016. Notwithstanding that, Your Honour the Chief Justice still gave Mr. Haigh permission to appeal so that if he had an answer to GFH's claim, he could present it. Well, today, almost exactly a year since the last appeal was heard, Mr. Haigh again says, I cannot progress my own appeal. And so far as the letter from Dr. Pollard is concerned, perhaps the first and most important point about it is to whom it is addressed. Your Honours will recall that Keystone Law came off the record last month. I understand Mr. Spragg has taken himself off the register of practitioners for this court. However, Dr. Pollard has addressed his letter dated the 8th of September so last week, to Mr. Mark Spragg, Consultant Solicitor, Keystone Law. Not to Mr. Haigh. So it would appear that Mr. Spragg is still collating evidence and material for Mr. Haigh. It may very well be that Keystone Law and Mr. Jones are still providing assistance behind the scenes. But Mr. Haigh pleads both litigant in person status and ill health preventing him from proceeding. We will never have an effective appeal in this case if Mr. Haigh is given his way. Your Honours have seen his lengthy witness statement, which is a catalogue of allegations against all and sundry, not least the officers and the judges of this court. any judgment other than one in favour of Mr. Haigh will be the subject of criticism, inevitably. But to file a 52-page witness statement in support of an application for an adjournment, and under the guise of an application for an adjournment to file a draft order with 10 substantive heads of relief, including seeking a direction that this court refers itself to various international bodies, and then to say I'm too ill to even move the application, is extraordinary, my submission. Dr. Pollard does not say addressing the court will cause Mr. Haigh to suffer a catastrophic deterioration in his health, requiring emergency admission to hospital. Indeed, Dr. Pollard's reference to Mr. Haigh not engaging with those he accuses somewhat sticks out in his letter. You may think it doesn't really fit there. Because what Dr. Pollard is talking about is a course of treatment primarily for opiate addiction. Now, as the Honourable Chief Justice said to Mr. Haigh a moment ago, he has made a very full application in writing. If it had been made by an advocate, it is very likely that the court would have said to that advocate, we have your lengthy written submissions. Is there anything you wish to add? But certainly the advocate would be prevented, and not least in this court, from then reading out those written submissions. It is up to Mr. Haigh how he chooses to progress his application. But he is quite free to say, I have said what I wish to say in writing, and I stand on it, and wait for us to respond. But what he is not free to do is to embark on this course of conduct, and then purport to present the court with a fait accompli. If it even considers the application he's put before the court, it is in some way endangering his health. That, in my submission, is simply not good enough. Can I assist Your Honours further on this point?
No, thank you very much, Mr. Botma. Mr. Haigh? Mr. Haigh, this is the Chief Justice again. Can you hear me?
Yeah, I can hear you now.
Right. Do you wish to respond to that in any way? You don't have to.
I do, but if we can have a short judgment, a short adjournment, so I can call my doctor if I'm feeling unwell.
Yes. Can I just tell you at this stage, unfortunately, I had an emergency meeting to attend in about half an hour's time. And then we have to break, we have to take an early lunch break in Dubai for about 2 hours, and we will resume again at 2 p.m. So just be prepared for that timetable to come up. We'll give you a 5-minute break. Is that okay?
I need to call my doctor, so it might be more than 5 minutes. He, works, so that I need to call him if I'm not getting well.
Can you call us back then when you are free? Well, we will call you in 10 minutes if we don't hear from you.
Yeah, I don't have the number to call, so if someone calls me back, it can take 10 minutes.
We'll call you back in 10 minutes. Right. Court adjourned.
All rise. Okay, I'm going to keep these two phones connected.
You know he's still breathing.
Fine, it's just the two.
Yes, no, do, because it...
Hello?
Yes, Omar, I'm here.
Okay, you can hear me?
I can.
All right, I'm just going to bring the recording and go back in.
Thank you.
All rise. Mr. Haigh, are you there?
Yes, I'm here.
Mr. Haigh, before the break, I was asking whether you wanted to respond to Mr. Bodmar's comments. You're not obliged to.
Yes, Your Honor, I would like to respond. Before I do that, though, just to update the call, I spoke to the hospital who advised me not to continue, and I, as you are aware from the letter, I'm suffering from withdrawal symptoms and have been physically ill. So I wanted that on the court record of the state that I'm in as I carry this on. But yes, I would want to respond to his comments, and also, as I said, to, if I must, formally take the court through my argument.
Just give us a short response. Then we'll discuss how we go forward.
I mean, my response is as follows. Mr. Bodnar complains and attempts to put in sorry, before I start this, can I ask one question? In terms of a litigant person, what duties does the counsel, in this case Mr. Bogdan and Mr. Stevens, have to the court that are heightened when there are no lawyers acting for me? That hasn't been explained to me in terms of what duty the solicitors and barristers in that case face to the court.
We have a mandatory code of conduct which is available on our website, and you can access that.
Okay. But I understand the duties of assisting the court are higher to the common law. Is that correct?
In general terms, the standards apply whether or not the party is represented. Outside of the court, there may be extra duties imposed mostly on solicitors rather than barristers. But let's not, get into the abstract. If you have a complaint, just raise it.
No, my point was in terms of when we're in court, if Mr. Duggan is saying something and Mr. Bogdan is saying something that is untruthful to the court, and they know you have to be untruthful, what duties were I can move on.
We don't deal with those matters in the course of the hearing. If you have a complaint against the professional conduct of counsel in court, you are free to take that to the proper body. We have a disciplinary body that hears such complaints, and the criteria will be what is set out in our mandatory code of conduct. But let's get on with the hearing, if we could, please.
Yeah, I understand. The question from my point there wasn't on that. It was what is the duty to the court? And I understood there was something higher in terms of what they deal with the court and how they deal with the single person and that. And it wasn't explained to me at the beginning of the hearing, but I'll move on. It seems to me that Mr. Dugan's complaint to the court and attempts to make him out as a person who is attempting to avoid the court and not engaging with the court and causing delay to this action. And I think the first thing that needs to be said is, why are we here? 3 and a little bit years down the line, 4 years down the line. Why are we delayed? Why am I there? Now, if we go back to 2014, had the claimant a genuine complaint, criminal or civil, against me, they could have made that complaint when the state is discovered an alleged fraud in January, so that there was the court thinking where I live. It did not. It spent the next 4 months, maybe 5 months, plotting and planning to coerce me to travel from India to Dubai so they could immediately have me detained, something which was not happening in England. And thereafter having me detained, seek to have me physically abused, seek to ensure that I could not have any documents on the court, seek to ensure that I could not send documents to the court, and obviously to seek to ensure that I had the worst possible time in my life, and I would say any other person in their life. That is why 22 months later the action has not progressed. Now, I think we need to look at what happened in November 2015 to see that the reason that we are here now with delay and why I feel now is clearly the plan of the training. In November 2015, I was to return to England and I was to appeal to the UAE Supreme Court, at which point I expected to do that fully in England and I had time to sit instead of my lawyer and to bring in the witness evidence, such as you see, my application to produce new evidence and others. Now clearly, that's not the line of the claim. It has a legally accusing the trafficking to Dubai and conspired criminally to keep me there. In November that year, at this time, the claimant was pushing the DIT court to list an immediate judgment application, repeatedly emailing and sending documents to the court and putting pressure on them to list an immediate judgment application. At that time, the claimant then criminally conspired to concoct another false allegation purely to keep me in prison for a further 5 months, while they again tried to escalate civil matters in England and in Dubai. Each time I was taken to the Dubai court, the claimant's lawyer deliberately sought any reason possible to delay my detention and delay the court. This was 7 times until the judge in that matter finally got fed up with the claim and acquitted me. That is why 22 months later there have been a delay and problems with the court. When I returned to England, as I mentioned earlier, I spent 5.5 months in hospital. Now, as the court hopefully is aware, during that time, including the first month last year, the first month this year, I did not have any contact whatsoever with the son-in-law. Now, I've seen references the court has made to the phrase gaming the system and pointing to the fact that I must have had contact and assistance with Keystone Law in September and last year when I was in hospital. That is categorically untrue. And Keystone has written to the court to confirm that it's untrue. I have never, nor am I now, gaming the system. Now, my point remains that the reason we are here is not because of me. It's not because of the court. It is the claimant's design of what they did illegally, breaking international and laws in Dubai and England to launch into a jurisdiction where they knew they could keep me detained at their will. And when I was due to be released, they repeated the false claims again to detain me. So, when the claimant complains about delay, it is their doing. It is no one else's doing but theirs. They have the option to report me to any authority in London. They did not do that. They had the option to issue a complaint about me in London. They did not do that. They had the option to issue a complaint to the DIT and not seek to illegally traffic me and keep me detained for nearly 2 years. But they didn't do that. They decided to concoct a dire criminal conspiracy to lure me from a country whilst I had just come out of hospital from stomach surgery, and they keep me detained for 2 years in conditions which are notorious around the world, and which the English High Court has refused to extradite Brits on the basis that there is a real risk of torture and on the basis that there is a real risk of unfair trial and discrimination. Now, in addition to that, the claimant seems to complain that I've lied to the tribe not to engage in the court. Now, since I've been released, notwithstanding that I've been very ill, I have done everything possible to put together a court file for myself and go through all the hearings that I was prevented from attending by either the claimant's actions or the court. And this runs throughout those hearings that the claimant is suggesting that I am attempting not to engage with the court. This is categorically untrue. The claimant has accuse me of something that I did not do. But they have destroyed my health and destroyed my life from what I mentioned previously. I want nothing more than to sit in an open, public, honest, and fair court with the resources to which I am entitled to defend the false allegations defending against me and to file the counterclaim against them. They have done everything possible to prevent that and continue to do that to this day. Now, the court itself will be aware that whilst I was jailed, when I had paper, and when I could get those documents out, I wrote numerous handwritten letters to the court. I wrote numerous handwritten applications to the court. They were, to summarize, to ensure that A, I could have money, my money, to pay for my lawyer, and the asset release that Sir John Chadwick provided for, that I had access to my money with sale, that I had access to my money to pay for living expenses. And they were letters written to the court complaining about treatment of me by the authorities. In those letters, as I set out clearly, it covers the fact that I was being tortured. That is written in a letter of May 2015, and that thread continues from 2015 until August 2016, when I was moved and not allowed to send any letters or allowed any documents or allowed to see my lawyer at all. Now, Mr. Bodman, in his skeleton argument, covered this point, suggesting that I have break the law. The DIT, in a letter that I sent out in statement, covered this point, suggesting that I haven't broken the law. The evidence is there, I have, and we are keeping the evidence. But I have continually and always tried to engage with this court when I have been well enough to do so, and patients to adjourn when I have not been well enough to do so. The reason why I do this is because someone accusing you of something you have not done is not acceptable, and I am not trying to run away from defending that. I want nothing more than to defend this. Now, this situation started in May 2014, when I believe my then solicitors wanted to put in an amended defense plan. That was denied by the court. So there is a need before the court before the defense plan. So bear with me one moment.
I'm sorry, I don't think Mr. Haigh has finished, unless there was some...
He asked for a moment.
No, I haven't finished. I'm just
Yes.
gathering my thoughts.
Yeah, I don't think it finished.
All I was going to say, and I don't know if Mr. Haigh can hear me through Your Honour's set.
I can't get.
Just hold on a minute. Let me just see what Mr. Bodmer wants. Just hold on a minute, Mr. Haigh. Yes?
Your Honour, I was only rising for this purpose. Your Honour asked Mr. Haigh if he wished to say anything further in respect of his application to adjourn on the grounds that he is too unwell to progress it. I note the time in Your Honour's timetable, and I am concerned that Mr. Haigh is addressing a great many matters that are not related to that narrow issue. If he is saying that in fact he is well enough to proceed with his substantive application to adjourn, given the time, and maybe he should do that at 2 o'clock Dubai time, 11 a.m. UK time.
Okay. Yes, Mr. Haigh, I wonder if you heard what Mr. Bodmer said?
I did.
Okay. Just purely as a logistical matter, how much longer do you think you want to carry on in this response, bearing in mind that you're actually only responding to what Mr. Bodmer has just said?
I would imagine perhaps another 10 minutes.
Okay, 10 minutes and then we'll finish and break for lunch and then we'll resume again after that.
Okay, thank you. Just bear with me one moment. Now, Mr. Bodmer, I will go through some of the points that he made. He said that he would object to an attempt for me to indefinitely stay proceedings in this matter, and I would agree with him. This is not what the application before you is intended to do. I would never ask, as Mr. Bodmer summarizes, no doubt to flavour the court, as an application to adjourn indefinitely because the claimants are that is quite a ridiculous suggestion. The application to adjourn is an application that's been put in place because 6 working days ago, my solicitors and my counsel were forced off the record for the reason that we have set out in the German application. Had they not been so forced off the record, it would seem to me that they would be arguing today the appeal. Now, the reason they are no longer working is an issue of money. They and I were under the impression from the Chief Justice's judgments that the money that the DRC court kindly released of 130,000 euros to assist me in having legal advice was to cover solely the skeleton argument and a bundle. And this is what was prepared, therefore that it was a provisional argument waiting the responses of the DRC court. As I mentioned, they are not here today because there is no funds to pay them. That is something which throughout the history of this case, again, the claimant has sought to prevent them from being represented in this matter. Clearly, I wrote to the claimant after I was off the record and invited them to agree to the use of my liquid assets to pay for solicitors so that they could be there today and continue. The claimant refused. Under both asset freezes, whether it is the AIMC asset freeze or the English asset freeze, I am entitled to spend an amount on the legal fee. Previously, in the DIC, the claimant stopped my access to money, liquid money, in the UK for 2 years, saying that I was not entitled to. When this matter came before an English court, the English judge immediately told me I wasn't entitled to and ordered the claimant to release it to a proof of debit. The point that I'm making here is the reason my solicitors are not there today is one because of money, and that point is one that the claimant has ensured is the case. So it's not an application to stay indefinitely. It's an application to adjourn for a period of 3 months in order that I may complete my treatment in the community and in order that I may avail myself of solicitors to finish provisional argument. So I wanted to make that clear that what Mr. Cox said is wholly incorrect. Now, Mr. Bodmer has attempted to make much of the fact that I have prepared a witness statement and that I am talking on the phone now. Now, Mr. Bodmer understands that he is not a medical practitioner, although he does tend to try and give medical evidence. The medical evidence is before the court, and the volumes from June 2016 until date with several psychologists, hospitals, and doctors and surgeons. I first became aware that I am likely to have to have my lawyers come off the record about probably 3 weeks ago, that it was looking likely. And at that point, I knew that I would be unable to continue at the hearing. And I started at that point, some perhaps 3 weeks ago, drafting the statement. Mr. Bodner gets the statement as this is basically on. We intending clearly to make the court think that I am perfectly capable and perfectly well enough to carry on in this hearing, despite the fact that there is clear evidence from my doctor that I am not, and despite the fact that the court should be able to hear from myself that I am not. And I've already been violently ill today, and I've had to take antipsychotics about half an hour ago, as well as contacting my hospital. The 52 pages he refers to is because I prevented the court double space the document to make it easy for the court to read. As the court will see from that document, it is repetitive, double spaced, and took me perhaps 3 weeks to prepare. So it is not something that I've done rapidly or quickly, and it has taken me a considerable amount of time. My illness is the illnesses to the damage to my bones and soft tissue is a psychological one. And when I work, I may be able to work for half an hour before having to stop, or an hour before having to stop. Just because it is not an illness where it is difficult does not mean that it does not exist. Now, Mr. Bob mentioned that when I went to hospital, the reason why this date was selected was, correctly, to coincide with both barristers' availability and to permit me to go to hospital, which I did. I went to hospital as an inpatient to Nightingale Hospital. I believe I was just going to April now, department of that case, but I went in 2 or 3 months later because of surgeries I was having to my knee and to my torso. Those surgeries were required to repair torture done to me whilst I was alive. There were complications from those surgeries which delayed my admission to the Nightingale. This meant that from June until August, I was in the Nightingale Hospital and unable to spend any time whatsoever with my lawyers on these points, or develop a skeleton argument that when I was released from hospital and had time to do that, my solicitors came off the record. Now, it seems to me that Mr. Bodden suggested the fact that I am talking means that I am well underneath with a full appeal. This, I suspect, is quite frankly nonsense, and the evidence is before the court. The damage that, and even this part of the court today, will do to me. He suggested that I'm well. Now, the claimants and their lawyers have ruined my life and my health. The fact that I wrote a witness statement as detailed as I could, shows my intent to engage with the court. Because not to do so would mean a judgment against me that would destroy my mind. Now, I have to deal with two issues. Last week, the IC court wrote a letter to me telling me that my German application would be dealt with at the beginning of the hearing today, and that should I choose not to attend that hearing, the application would likely be struck out and the appeal hearing continue in Haigh. Clearly, that would have meant that I would lose my appeal and there would be an award against me. That award would, as I have said, destroy my life more than it already has been. So I had a choice. I either sit back and let an award go through. And after 4 years, when I've not once been given the chance to speak to court, and not once been able to bring any witnesses, and not once been able to cross-examine the witnesses and the evidence and the claim. Or I make myself further and further ill and risk my mental health recovery. I had those two choices. I had to make a choice. And therefore, that choice I made at that time was that I would try to have the hearing adjourned so that I can get proper advice and assistance and time to prepare the appeal hearing. Now, Mr. Bodner has today, and throughout the arguments, and Mr. Dubin's in his letters, including at least the letters to my psychiatrist, has tried to belittle the letter of Dr. Pollard and tried to, throughout time, belittle the illnesses which I am suffering. And again, I would want the court to clear and unequivocal evidence of, I believe, about 5 or maybe 6 top psychiatrists and psychologists that have all concurred on the same point. Surgeons that operated on me to repair the damage done by torture. Now, Mr. Bodner attempts again to detract from the fact that why am I ill? And why do I need to journey this assignment? I am ill purely and solely because of the criminal act of his clients, GFH Capital. Had they not brought me to life, and had they not sought to have me abused and beaten, I would not be adjourning any matter because of those injuries, because I would not have them. The reason I'm adjourning is, again, purely because the claimant chose to act only in gross abusive process. Now, to put clarity on the letter, Mr. Bodner attempts to make a large amount of capital from the fact that it was addressed to Mr. Spratt. Throughout the time when I was in that hospital last year and this year, I've seen attempts by sorry, I'm feeling a little unlost. Give me one second. Sorry. Mr. Bodner has attempted to suggest, and certainly also took his position before, that as I mentioned earlier, that I was gaming the system with Keystone, and that I must have been in contact with Keystone, and that Keystone must have assisted in preparation of applications by me. And as I said, whilst I was in hospital, I was never in contact with Keystone. And Keystone never assisted me with any of my applications that I had made. He seems to suggest, by the fact that the letter is addressed to Mr. Spragg must mean that Mr. Spragg is assisting me. This is wholly incorrect. Mr. Spragg further did not come off the record last month, as Mr. Bodmer tried to suggest. My notice of change is clearly dated 4 September. That notice of change was accepted by Ms. Lena Hatton at the beginning of this week, and she informed me that that is the date that I am fast of becoming politically inconverted. The letter was addressed to Mr. Spragg as I simply spoke to my doctor and asked him to send me a letter that I could give to the court, and he kept Mr. Spragg's address. So there is nothing received from the fact that it's addressed to Mr. Spragg.
Mr. Haigh, I'm so sorry to interrupt you, but you've been on for more than half an hour. I need to go off now. So, how much longer do you think you will need after lunch?
Just on the medical point, just one more point on the medical point.
Okay, finish it off.
Okay. Now, in the letter, Mr. Bodmer also attempts to belittle my illness by suggesting it is an opiate addiction and nothing else. This is not true. An opiate addiction is part of the illnesses I am suffering from. The opiate addiction arose from the fact that I was prescribed morphine and other exceptionally strong opiates to deal with the severe pain from torture. Now clearly, there was nothing wrong with them. General practitioners could not be prescribing morphine at such quantities that I was being reliant upon. That again is the sole and direct result of the pain that is at hand. So I will stop there in the room. I have perhaps 5 to 10 minutes more in responding to Mr. Bodmer's points, and then I would need to, unless the court wishes to adjourn on the basis of what I said already, then I would need to set out my application to adjourn, which I honestly don't know how long it would take, but I believe imagine several hours. Like I said, the first time I've ever done this, so I wouldn't put the first time I've ever done something in detail, as it were. So I wouldn't know how long it would take.
Yes, okay. Mr. Bodmer wants to say something. Yes, Mr. Bodmer, quickly.
Yes. Your Honour, the one respect in which Mr. Haigh is right about the particular status of the litigant in person is that if counsel feels that it may be that there is a different way of putting what the litigant wishes to say, they should. If I understand Mr. Haigh correctly, the last half an hour has been devoted not just to the question of whether the court should adjourn his application to adjourn, but also on his substantive application to adjourn. It would appear that, in fact, a large number of the points that he's been making are related to that substantive application. Obviously, I have a response, but Mr. Haigh won't need to make those points again. If, in truth, he has chosen, notwithstanding medical advice, to put his application before the court, he should complete that at 2 o'clock, and I will respond.
You mean 2 o'clock? 2 o'clock. 2 o'clock. No, we'll sort this out at 2 o'clock. All right, so we're adjourning now, and we'll come back at 2 o'clock.
All rise. Deputies, okay. Okay, we will come back in just before 2 o'clock and reconnect again, just over 10 minutes before the hearing. Okay?
Yeah, we'll be able to come in a bit before and we'll come
Yes.
back. And it's better to have a
Schengen and such.
No, we're not in Schengen.
They're temporary border guards between France and Italy. The fact they're still there, there's a very good reason.
We're not in Schengen.
No.
So we
But
would
there
have
would have been a question mark over the independent Scotland and the high border.
countries more. So, well, it's a bit hard. One can assume that there's something like the border between the UK countries.
No, but the point is, their campaign for independence was a sort of trust-fairy independence. So Mummy and Daddy actually provide everything, but they get to say, I'm independent. Me, Daddy, how am I supposed to stand on my own 2 feet?
So it's like the university student moving over for the first time.
Yeah, that was basically it. That was
Did you ever read Student Grant in his?
No.
There's one where he's talking about standing on his own 2 feet, and it's sort of labelled one term's worth of number one. I thought you found this one. I thought you found this.
I did. And it's been read on me both. I said I can't remember too much.
Some of them, some of it was just pure art, but some of it was
Which if you were a teenage boy, it was...
well, yeah. That's something was in there.
What time did they come in? 2 o'clock. And it is 5 hours. Well, there we are. There's a movie called Chappaquiddick.
What's that all about?
Ted Kennedy is sacked on driving him. He drove his car off a bridge and left his staffers apparently. What was it? Do you know?
All right.
Hello?
Hi, can you hear me? This is Nima.
Yeah, it's disconnected, I can hear you.
Okay. The court of appeal has now been brought into the courtroom.
Yes, apologies for the slight delay. Mr. Haigh, would you like to finish your comments?
So, in terms of a response to what Mr. Bodmer said, I believe I've covered all the points I wanted to present. But if I now need to go through the adjournment application, is that correct?
No, at the moment we are still hearing your arguments on why you need to postpone your application for adjournment for another 3 months. So if you finished your response to Mr. Bodmer, then I think we're done on that. And Mr. Bodmer, do you have a very short reply?
Your Honour, there were a great many things in Mr. Haigh's address which were not really a reply to my submissions.
Sorry, I can't hear you.
Okay, can you hear me now, Mr. Haigh?
Not really, very quiet.
Is that better, Mr. Haigh?
A little bit, yeah.
Yes. There were a great many things in Mr. Haigh's address to Your Honours which were not truly a reply to my submissions. Perhaps I should say...
But why don't you just confine your responsive comments, which actually technically we could do without, but I'm just giving you an opportunity to just add anything.
I can hear you.
And the reason... Mr. Haigh...
Okay, let's just pause a minute. Mr. Haigh, just hang on a minute. We'll just get the acoustics right, and then Mr. Bodmer will carry on.
Mr. Haigh, can you hear me? Mr. Haigh?
You're very...
Okay, I will speak loudly.
Or maybe direct yourself to the microphone, or we could put it closer to you.
Is this better, Mr. Haigh?
Yeah, a little bit.
Okay.
I don't know, Mr. Bodmer, if you
It was
sat
fine
down.
Before. What happened before the break? It was fine.
Your Honour, I'm sitting down, Mr. Haigh, so hopefully now that I'm a lot closer to the microphone, you can hear me better.
Yeah, that's better now.
Yes. Your Honours, 2 points. Firstly, Mr. Haigh appears to have addressed a large number of the parts of his substantive application for an adjournment, if I can put it that way. If he's well enough to do that, he's well enough to complete that application. And secondly, a matter Mr. Haigh has not addressed in the over an hour in which he addressed you. Yesterday, he asked us to agree to the release of 40,000 dirhams to fly to Dubai to attend this hearing. So yesterday he was well enough to fly here for this hearing. Today he's not well enough even to move an application for an adjournment. And given that I don't have any further right of reply, perhaps I should pause there.
Thank you. What I think we propose to do now is that the panel will withdraw. We will consider the arguments made, and we will call you back. We don't expect to be very long, perhaps 10 to 15 minutes. So please be close by, and Mr. Haigh, if you could stay available, and the court will call you back when we're ready to resume again.
Just, can I ask a question, just so I'm clear? This isn't the adjournment application. This is a preliminary point on whether we adjourn the application for later. So it's not actually the whole adjournment application.
Correct.
Okay.
All right?
All right.
We'll be with you again shortly.
All rise.
Yeah, do you want to call me back?
Yes. So I will probably call you back in about 10-ish minutes, if that's okay.
Okay.
Okay, thank you. Bye.
Should we talk outside?
Yeah.
Well, frankly, if we don't
Or was the LAP defendant?
He was one of the candidates. He was a slow counsel. Slow better role. You know what else?
I heard the term, but you have to define it.
You go to the key, to down the horse.
Yeah.
You go just before the church, which is about 10 seconds before you go.
Yeah.
Take your time paying the bill.
Oh, okay. Yeah.
And if the horse gives you a play, you pay and you go and collect. The horse doesn't pay.
Yeah.
And he was variation of the theme of using dodgy debit cards. Are you just watching or in? Oh, right. This is a once in a lifetime opportunity to see something like oh, yes. I was thinking to myself, well, yeah, I'm glad to go. I need to curse my heart and send it to us. Now I'm fighting 1 hour since to fly 7 hours.
No, the one
Okay,
case.
so I need to bear in mind to not only come to a decision to cross the meeting.
No, no,
So
no, no.
just keep me on. What would be the judge? Yeah, decision.
Yeah. Yes, yes. Yes,
I don't know as a whole. No, it's just the other if you protect me. And if you go up there saying I'm going to do this president in the world, but 2011 feels like a brand new building. Since everybody exists. But my wife was in New York, it's like a license. Well, I'm a theme.
And can I take over this one?
Yeah.
Sorry, I'm trying to get Wi-Fi working again. Wi-Fi is going to work. Oh. It's all stopped.
Is it an email?
No, wait a minute, wait a minute, wait a minute, wait a minute.
How did you get that?
James, you.
How did you get it?
Could be.
Sorry? So is this?
Okay, I'm trying to find it. I just don't have very good internet access.
Yes. So it is feed current. Right.
11th of September to the 29th of September.
When is his date of speaking?
Yeah.
No, that doesn't matter. And the fact that he is in it.
Yes, he's going to be invited to talk.
No, he has been, but
Well, do you want to have a look on your website?
no,
Says it.
no.
Why? He'll just deny it. If he is, that's true. If he is, he'll just come and do it.
Right.
No, okay. No, that actually that would do. Should I show you email?
Yes.
Email?
No. So, see, watch it from this. Because this is actually
Okay, David Haigh has an open Instagram account.
Okay.
You may want to see what's on it.
I'm not sure that it's any of my business.
No, it's directly relevant to this here.
Not to me.
Oh, I
It may
see.
be relevant to the Court of Appeal. It's,
Well-
I mean, you can show it to me, but
Yeah, can we show it to you to work out the best way to show it to the court?
I mean, they can cast one off around if they want, as long as they don't.
Okay.
So yes, passed, as you can see, it's between yes, September and 29th of September.
This is something they should see.
You can, if you wish to, I mean,
Can we email it to you?
I wasn't.
You can take a screenshot and send it me by email to the registry. I can then print it off if you
Would
want
that
to
be
show
the best way
it.
to do it?
Yeah. However you want to do it, but that's one way if that's how you want
Can
to
you do that? Go see.
I can text you, can't I? Yes, you can. Do you have WhatsApp? Yes. On my personal.
Actually, can you just go onto Instagram?
Yes. Can you say yes? You
Can you go onto his account and get a screenshot?
Yeah. It'll take me a second. Thank you. Yes, madam. You need to take a screenshot.
This is his own broadcast.
This is open broadcast. I haven't pretended to be someone else to get it. This is my own. I'm getting access to my own. The public Instagram account.
Under your iPhone, can you recall how you take screenshots? Are you using the top button?
I don't use iPhones.
Yes, I do. I know.
Ah.
It's,
Yeah, this is the iPhone 6S, so there isn't a top button anymore.
It's tempting to say, is it possible to go onto the ISC computer and just open up his Instagram account and print off? But you need to focus on their making anyway.
Yes.
So.
They're still discussing. So.
Does that mean you don't have to take a screenshot on that?
I have taken a screenshot of that.
Aha, excellent. So you're not going to email it to the registry.
This is my personal email account, which I do not want to send to the registry. But it's not that I don't change it, not that I don't want the registry to know my personal email account, but you know who I don't want it to pass.
It's okay. It can be redacted. We're not going to give it to Haigh. We're going to print off what we give, and I'm going to ask Haigh to open his Instagram account. I'm sure he can open his own Instagram account.
I'm sure you can. I will send it to make it work, and then I'll pass it on. Would you be okay to make sure that my personal email is redacted from anything passed on to you know,
Just basically put a Sharpie through it.
Yes, but it's not for me to make that decision. It will have to come from the public.
Okay. I mean, there's no real reason to show you the document with his own Instagram.
Yes. It's entirely up to you. I will leave it up to you how you want to proceed. Let me just check if there are any.
Yeah. It's not. The email is possible. Yeah.
That's I'm sorting it now. What is the register for the anyone else for the IC registry? I haven't got it.
I took time to come.
It's just email me the email address and I'll reply to it. Just have the description.
It's just reading the internet here. Even my phone isn't working, but the internet isn't working. We had our work friends improve.
We have no sort of tutorial on how to use them. So for example, if I have to use contacts, you better hope that person trying to contact I contacted in the last 2 days. Otherwise they're just like that.
Yeah, you can, because that's true.
Or if it's easy, I can just send you an email back and you can just forward it to the DOC.
No, I'll just actually send it to the DOC.
With a message saying, please approve. Fine.
I can't forward your message because somebody else has an email address.
Did you say you've got a screenshot?
Yes, and an email. I just sent the email address.
Leave email. What's the best email address?
I'm sending it to the registry.
Registry.
Registry at the IC.
Yes.
You're sending.
Yeah.
Okay. Rob's sending.
Okay, that's fine. And I mean, need him to leave my personal email. No, it's not. These phones are playing up like crazy.
The other thing is if it's your personal account, there is no presence. There may be-
You can appreciate why I wanted that to.
No, I get that. But in terms of the efficacy.
No, I know that.
I'm sure Brian Kate paid for all the network provider insurance.
Yes, that's true. Does that mean that doesn't mean yes, it's better service than what I get from the carbon warehouse?
But there's some in this sort of extremity.
Yes, I'm not so sure.
Anyways, it's gone.
It's got this. It's bad. That's been sent to me.
Eva. Yes?
Let me take that.
What was that thing you had? Tell me where he is. I think he did take a screenshot on this.
It's the 36th session of the imagination. And what's the official title?
The official title is United Nations Human Rights Office of the Commissioner.
Do you have access to a computer that you can use here? The answer is yes, and you've got internet, right?
Yes.
The reason I ask is the Court of Appeal will be transmitting something to both parties. Well, I will send it to you as a sort of aid memoir. I just need to make sure that you have access to the computer. I will do the same with the appellant.
Of course. That's it.
That's it. Yeah.
Hello?
Hello?
Hi, this is Lima. The Court of Appeal are still not in yet. They need another about 5 to 10 minutes. But I just wanted to check. Do you have access to a computer?
I do, yeah.
Okay, because the Court of Appeal, when they come back in, would like to send something to both parties, just for them to have it sort of in front of them while the Court of Appeal goes through it. And I'm just making sure that you will have access to a computer.
I will do, yeah. Well, I have to, it's the same thing, so.
But you'll be able to receive something from the registry for you
Yeah.
to look at. Okay, perfect. I will call you back in about 5 to 10 minutes when the Court of Appeal are ready.
All right, thank you.
Okay, thank you. Bye-bye.
Which is the Wi-Fi network that works best?
It's the court guest,
Court guest.
and the password is 7*, SEVEN*.
The special character.
No, STA. Sorry.
Spell out 7 star.
Yes, spell out 7*.
Apparently that's one of the more secure passwords you can get. Connected. See if it works. Found it?
Here we go. No, not quite. How about the 28th of June? Something here, though. Oh.
What?
I no, it's a different piece of work.
Hmm?
Yeah.
I'll copy you so you know what I'm talking about.
Right.
The email, so. Yeah. It means something needs to be you, effectively, that gets to auction a vehicle.
Yeah.
Yeah, auction that vehicle. I literally have no idea what the price of that vehicle is. I don't want to know what the price of that vehicle is. It's actually quite funny.
No, Haigh doesn't turn up in the programme for work.
No, I can't find it.
Can you forward me James's email? Please. The one with the password.
Yes, no, I've got the password over the standard email.
Either one can be forwarded to me.
Yeah. Sorry, I thought I had it. You should have it.
It'll take a moment to come through.
No, no, no. Sorry, I was trying to stop something.
Out of curiosity, did it say that it was going to personal organisation? So actually,
So, it just says NGO, which is the one he set up in the last.
just wondering if that was on the list instead of his actual name.
Sterling Law is the group detained in Dubai.
Did that appear on the programme? That's using that.
Probably no matches either. Unfortunately, I can't access any of the documents.
Look and I.
Oh, really? Yeah.
Aha.
I thought that was working out, but it doesn't actually say so.
Ah.
What's that song actually called? So just can't get it.
Found out how to get access to the documents.
There's apparently a theory that Rockabye Baby is about James II and Sir Sam's child. And when the wind blows, the credit will fall for Protestant Britain that brought King Philip to England. Bandit. Is that who it was?
footer to say, can I be invited to talk?
I know what it says. The date takes it. I can't find any evidence of him actually addressing the session. The first time I went there, I'll tell you why. Later on, the conversation ends, but essentially I was there to help Indigenous people of Canada on the country with their complaints about behaviour in the Canadian government. Overnight, the events in the present regime will come out, which is basically a humanitarian crime by its own. And as you might imagine, even see our government department everywhere in sessions, and I have to say to this poor guy, you've got to appreciate it to some point. But what I can tell you is that you do not just get one of these passes. So I was fake. Which is, let's see. And I was fake. Or it's been very careful in the plan. No. Lehman, did you receive?
We've received it. I'm just waiting for the proof of guilt to be available so I can ask them what they would like to do with it. But I can imagine the position will be that you will need to serve it if you haven't already done so. But I will just wait to hear just 2 minutes and then I will let you know what we will be doing with it.
Yes.
Okay, so before the court of appeal will look at it, the first thing is that it will need to be served on the appellant, and then once we start the hearing and the appellant has confirmed that he's seen it, they will take copies. I've got printed
That's
copies
fair
to give them. So if you could just make sure that
So
you
could you email it to
email
the
it
address
to
that
the
says?
appellant, please.
Yes. Which email address is the court directing us to use? You said
The
DFE.
one that we correspond with them on.
DFE.
The same one that we correspond with.
You appreciate it.
Yep.
Yes.
Why did you say that?
Is there a document that I will be emailing you a copy of now?
Do you want to email it to me as well direct? Actually, no, if you're going to copy in David Haigh.
No, I suggested that.
Not if you're copying in David Haigh.
I'll be ready 5 minutes.
Okay. Well, I don't know, that depends on my computer. It'll come. Look, it's working.
It is actually working.
Their Wi-Fi is working brilliantly.
It is now. It wasn't 10 minutes ago.
You know.
I'm not.
Look, one of the things that Wi-Fi fluctuates is if a lot of people are
Thank you.
and bear in mind that the DIFC server doesn't just take up
I'm not ascribing any.
so if somebody just uploaded a hearing bundle that is 16 gigabytes.
Yes, or if a new video, if a new sort of here's the court video, because
It's being watched.
Yeah.
It's being watched. I happen to know the other video isn't volume because the player takes a good time. It's the bandwidth, how many people are watching certain things, because each one is, but that all comes into one server.
So 3 or 4 people are watching you. I listen to the cool. That kind of
Okay, I have to send that to you. We have a project in the event that it is required. Very beautiful.
I haven't got it yet.
And I'm going to.
Oh, but that's a sent it yet.
Hello, can you hear me? Hello?
Hello.
Hello, hi, this is Nima, can you hear me?
Yeah.
Okay, I've just sent a document through to you and to the respondent's lawyers from the Court of Appeal. But don't worry about having read it as long as you've got it in front of you. And I will then bring the Court of Appeal in and they want to take everybody through it. Okay?
Yes. It's the one I used to.
All right.
Do we have Mr. Haigh on the line?
Yes. Mr. Haigh, are you there?
I am here.
Mr. Haigh, have you received a document sent to you by the registry called Suggested Course of...
Could you turn the volume up a little bit, please? It's quite faint.
Have you received a document from the registry entitled Suggested Course of Action for Discussion Purposes Only?
I have, yeah.
Thank you. I will now take you through what the court is thinking, all right? So this is what appears to the court to be the most appropriate way of dealing with the current situation. The first point that we want to make is that we would be inclined in any event to dismiss the current application made by Mr. Haigh to postpone the application for adjournment for another 3 months. That's what's in our mind. Secondly, if we do that, then we then address the substantive application, which Mr. Haigh made a couple of days ago, to adjourn the hearing of this appeal for 3 months. We are also inclined to dismiss that, and it would then follow from that, item 3 on the list, that the Court of Appeal would then proceed to hear the substantive appeal. And then we get to item 4. The Court of Appeal has already fully reviewed the relevant papers in this appeal. We formed a tentative view. And the tentative view is that this matter should proceed to a full trial. Actually, that there's an error in that. Not the final trial, but it might well be the final trial. To a full trial in view of the special circumstances of this case, which would bring it within the rules of court Part 24.1, Sub-Rule 2. For Mr. Haig's benefit, that rule provides that immediate judgment will not be granted if there is some other compelling reason for trial. And it seems to the Court of Appeal at this stage, not yet having heard Brian Haigh and Mr. Haigh, that is the way it's coming out. If the view of the Court of Appeal is either accepted by the parties as the way forward, then certain other consequences will follow. If the view of the court is not accepted by the parties, then it will be fully argued, and after full argument, if the Court of Appeal still confirms its original view to dismiss the to allow the appeal and to send the matter for trial, then the following items will apply. And at paragraph 5 or item 5, we say if parties don't accept what the tentative view of the Court of Appeal is, then of course the Court of Appeal will allow the parties to fully argue the substantive appeal now and or tomorrow. But if we decide after hearing argument that we are still minded to allow the appeal, then of course this case will go for a full trial. Likewise, if the parties, having considered all the options, accept the preliminary view of the Court of Appeal that this case should go for trial, then at the moment the Court of Appeal is thinking that it will order a relatively early trial, and that trial date should be in January, which is one more month than what Mr. Haigh had suggested. What we then think that is, at this moment, of course, we are throwing this out for parties' consideration. You are not aware that this is the way that we are thinking. And we think that the most sensible thing to do at this moment, subject to whatever immediate reactions that you may have, would be for parties to we adjourn this case overnight. Lawyers go back and take instructions, come back tomorrow and tell us what your decision is. And likewise with Mr. Haigh, you may want to go and consider this overnight and take advice from whoever you want to. And then, as a sort of gentle prod to you at item 7, if you come back and agree with the course of action proposed by the Court of Appeal now, then some of these issues that we listed are for your consideration, so that you can come back and make some proposals, because the Court of Appeal would like to ensure that we can make as many case management directions that we can at this stage, so that some things are settled and will determine the course, so that you don't have to come back and for special orders. I mean, some things will have to take its course, like discovery, but think of what are the things that are likely to require special orders, and then could aim towards that, so that we can then fix a relatively early case management conference before the CFI judge, after we go away from the Court of Appeal. But whatever can be decided at the CA level in broad terms of principle, let's decide it now. Yes, Mr. Omar, you want to say something?
Yes.
Why don't you sit down for the benefit of Mr. Haigh?
I'm grateful.
I
I haven't started speaking yet, Mr. Haigh. Can you hear me now?
yes.
So, Your Honour, in a moment I'm going to ask for a few minutes to take instructions. I hope you appreciate it. But just by way of perhaps assistance to Mr. Haigh, as well as Your Honour, and also for clarification. So points 1, 2 and 3, obviously we would have nothing further to say to Your Honour. ask for an effective hearing of the appeal today. I anticipate I will be instructed to resist point 4. It would assist if the court could give an indication of the special circumstances justifying the trial which it has in mind.
We are weighing up the starting point is that the court feels.
Sorry, I can't get the Chief Justice. I can't hear him.
Mr. Haigh, can you hear me now?
Yes, I can. Thank you.
Right. The starting point is that the Court of Appeal feels that this is one of those cases where the witnesses ought to be heard. It involves a case where there are allegations of fraud and dishonesty and breach of trust and fiduciary duty. There are contested issues of fact and to a certain degree of law, but it is the factual issues that need to be really aired in a trial with the opportunity for Mr. Haigh to cross-examine the witnesses as well as to bring witnesses of his own. Then you couple that with the logistical and other difficulties that Mr. Haigh has in, first of all, dealing with just with this hearing alone, and the other circumstances which were mentioned at the previous hearing of the Court of Appeal. So those would be the special circumstances that the Court of Appeal would find compelling to have a full trial. Matter of principle, matter of pragmatic case management, the theoretical possibility, if we were to actually rule on merits if we were to look at Mr. Haigh's applications for 2 adjournments, effectively of 3 months plus 3 months, plus his other applications for additional evidence to be introduced, all of which I think would become moot on this approach, plus the fact that the respondents, the respondents to the appeal, GFH effectively have, it is not clear to the Court of Appeal how much serious prejudice would result to the claimants from this particular approach, apart of course from the extra cost of a full trial, having regard to the fact that they have obtained the order for freezing of the assets which have allegedly been misapplied by Mr. Haigh, and they actually have not pursued the application for the remaining remedies, which is the cash that they do not have in hand. So these are all various factors which we have taken into account in arriving at our our assessment as to what would be the best course to take under the present circumstances. Okay, mute. Just to remind you to sit down again, Mr. Mwapa.
I'm very grateful. I'm very grateful for that indication. Can I ask, when the court says that the respondent, as GFH, has not pursued an application for
the remaining
balance of its remedies, is the court aware that we've issued a claim in the commercial court in London against Mr. Haigh, his sister, and his various companies, seeking declarations and various other relief consequent on judgment with a view to getting in those assets.
Okay.
And that application, and those proceedings, Mr. Haigh has asked not to progress until after this appeal is dealt with. I'm simply asking the court to make, I'm simply asking if the court is aware of the existence of that claim when they say that we're not pursuing our other remedies. And also, can I ask if the court is aware that Mr. Haigh made an application to stay proceedings on shore against his apartment in Dubai, which was granted earlier this year, which was granted by this court until after the appeal was dealt with.
Sorry, can I respond to that, please?
Fine. Please do.
Right, so it's just focusing on what Bob said and not the Court of Appeals proposal. Firstly, in terms of the applications which the claimant was taking in Dubai, now, as soon as it was out possible, and well, in January of this year, I made an application to allow me to sell part of my assets so I could pay for it. And I made an application to throw out the existing freeze on the basis that there was failure of full and frank disclosure. Those applications are currently with the court. Now, after I made those applications, the claimant sought various different types of additional asset freezes. At the first of those, the claimant was told by Justice Phillips that it was the incorrect order presented today, that the asset freeze was not a proprietary one, and that if they wanted a proprietary one, they should make an application, which they then did at a hearing that I was in hospital for. Now, it's correct to say that they have pursued additional reliefs because I don't know quite how those are additional. Now, if anything, all what they pursue secures the assets even more. And I'll give you an example. Mr. Dugan's acting not at the time for claimant, but for CEO Mr. Chalarai and a former CEO, Mr. Dinesh Patel, sought to have charging and debt orders placed over my bank accounts that had a negative or nil balance. My property that I was seeking to dispose of through court so that I could have money to pay the living expenses and legal fees. So if anything, since the beginning of the year, their protections have increased dramatically. Because now if we take the farm for a moment, there is an asset freeze by the DIC, there is an asset freeze by the UK, and they are now charging and debt orders in the name of the CEO of the claimant personally that cover it. So they are voluntarily protected. So it's not correct what Mr. Gordon says. I did want to correct that. Thank you.
Yes. So, Your Honour, the question was directed to the court whether it was aware of the existence of a claim, not an application for interim relief, a claim for final judgment issued against Mr. Haigh, his sister, and various of his companies, and also whether the court was aware that Mr. Haigh had sought an order staying enforcement of the court's judgment. I don't know whether the court was aware of that when it said it was planning to pursue our alternative remedies. If the court would be assisted, I'm sure we can dig out the necessary. If I could please, Mr. Haigh, please, if I could complete the list. So far as item 6 is concerned, so far as item 6 is concerned, of course, we would ask for a speedy trial if a trial is to happen. And so far as item 7 is concerned, as I understand what Your Honour is seeking, is that the parties should overnight turn their mind to what should happen in the event that the court allows an appeal, whether by consent or by judgment, to what directions it would be appropriate for this court to give to facilitate that trial, as opposed to a judge of the court of first instance at a case management hearing. And that we will, of course, turn our minds to those directions, even though I anticipate my instructions will be to argue for a determination of the appeal against Mr. Haigh. But with that, having said that, can I ask Your Honour for perhaps 20 minutes to take instructions from my client before I start to go down the road, just to ensure that I am instructed to go down, because Your Honour will appreciate this is new to us, and I feel it's appropriate to take full instructions before I address the court as to what our approach will be.
Just to be clear, you are taking instructions, and in 20 minutes you'll come back and say your instructions are to go ahead to argue the appeal. So we then have to decide, if you take that position, we'll need to hear, obviously, from Mr. Haigh to a limited extent, I think, on item 2. I don't think we need to hear anything further from Mr. Haigh on item 1, which is his preliminary application, which we've been fully argued. And the second one, we'll see what Mr. Haigh has to say. So during the 20 minutes, he can think about what else he wants to add to it. But I think one way or the other, so you want to start your argument on the main appeal then immediately?
Perhaps, would you excuse me if I shout for speed, yes, is the answer. Okay. Although it is Mr. Haigh's appeal, and so he would expect to go first. Can I propose this? That having taken instructions, we consider the best way forward. What I just said, I was trying to simply shout to speed up the process. But what I just suggested was that the short answer to Your Honour's question is yes, that is our position. It is, however, Mr. Haigh's appeal. One would expect him to go first. But perhaps, assuming that my instructions as I anticipate them to be, and assuming we get to the point of a full hearing, because Your Honour's dismissed the application for an adjournment, perhaps I could take 2 or 3 minutes to assist with the structure, perhaps the most helpful structure for an appeal, in light of Your Honour's comments about the court's preliminary review. And perhaps that would be the best way forward. And with that, perhaps if I could ask you to rise, it doesn't call for a response from Mr. Haigh. If I could ask you to rise, I will take instructions as quickly as I can, but in no more than 20 minutes.
Mr. Haigh, hello, Mr. Haigh, we will now adjourn for about 20 minutes. You'll be contacted again when the court is rising. Okay?
Thank you.
We'll speak to you shortly. Bye-bye.
All rise.
Lima will probably be outside in no small measure, just so that we can have...
Sorry?
We'll probably be outside even when I'm not smoking, just so that...
That's fine. You take your time. If you want a meeting room, you can ask the receptionist if one is available.
Okay, that should be okay. Thank you.
Lima. Hello?
Hello?
Hi, this is Lima. Can you hear me?
Yeah.
Okay. I'm just going to bring recording computer, okay?
Thank you.
All rise. Mr. Haigh, are you on the line?
Yes, I am.
Okay, thank you.
Mr. Butler?
Yes, Your Honour, thank you for the time. As I anticipated, my instructions are to resist an appeal by consent and to seek to persuade Your Honours that Mr. Haigh's substantive appeal should be dismissed. That, of course, engages Mr. Haigh's application for an adjournment. Before Mr. Haigh proceeds with it, could I say two things? Firstly, and this is for Mr. Haigh's benefit, he has addressed a great many of the wider issues in his address to Your Honours earlier, and it is not necessary for him to address them again on his wider application for an adjournment. Secondly, can I ask that a document be handed up to Your Honours, which we emailed to the court over the short adjournment? Now, this document has been served on Mr. Haigh by email at the same address which the court has been using, including, and I look to Your Honour's associate to confirm, including the email address to which your aide memoir was sent. The document Mr. Haigh can also see because it's on his own Instagram account. And Mr. Haigh's Instagram account is a public account. One doesn't need to have any sort of special access to see what he posts to the world. Now, what Instagram does, in one of the things it does is geolocate. And it's Mr. Haigh's own Instagram account suggests that he is at the United Nations office at Geneva today. What he has posted is presumably a scan, it may be a screenshot, of a pass to the Palais des Nations in Geneva, which is a United Nations building predominantly for the Office of the Commissioner for Human Rights, to which national governments send down permanent ambassadors. It's an entity that I have been party to addressing submissions for many years ago. It's very large and very well-known entity. What Mr. Haigh has posted is a pass in his name, Haigh David Lawrence, status NGO. So he has represented to the world that he is attending the 36th session of the Office of the Commissioner for Human Rights of the United Nations as a delegate of a non-governmental organisation. Your Honours will note the date. The dates of this session are Monday the 11th of September of 2017 to Friday the 29th of September 2017. In other words, Mr. Haigh has represented to the world, notwithstanding his protestations of poor health this morning, that he is going to Geneva now, and is in Geneva now to attend a session of a United Nations organisation. On top of that, he has posted, and you see, thrilled to be invited to talk at, and I can tell you if you see the whole screenshot, at the 36th session. In other words, he's representing to the world, not only is he attending this session, he's speaking at it. Now, either Mr. Haigh has manufactured this screenshot and is puffing himself up to the world in the most extraordinary way, or what this shows is that Mr. Haigh has such contempt for this court that whilst addressing it on the basis of his poor health and the need to contact his doctor, and that he cannot possibly proceed, he is in fact in Geneva. And we say that is a contempt in the face of the court. Now, one final point on the provenance of the document, since Mr. Haigh will no doubt raise it. As I say, Mr. Haigh has a public Instagram account. He chooses to post what he is doing to the world. And one of our colleagues in London had a look at it shortly before the short adjournment, and shortly after you rose, Your Honour, he forwarded this information and this screenshot to Mr. Judith, my solicitor. So we say that this is an end of the application for an adjournment of the appeal. But Mr. Haigh will no doubt address you in a moment, and I'll respond more fully to the appeal, to the adjournment application. But also we say this is nothing short of a contempt in the face of the court, because he's posting this to the world. For anybody to see, including an official of this court. And with that, I'll hand over to Mr. Haigh.
Mr. Haigh, you can now address the court.
On which point? On the suggested course of action? what Mr. Bodmer has just said, or both?
We are now, okay. For the record, the tribunal has considered the arguments of the parties on Mr. Haigh's preliminary application to postpone the application, his application for adjournment of the appeal for 3 months. And we have decided to dismiss that application. So we are now considering Mr. Haigh's substantive application for adjournment of the appeal hearing. And Mr. Bodmer has just made some remarks about that, and Mr. Haigh is now invited to reply.
Okay, thank you. Firstly, let me clarify something. I did not request a 3-month initial adjournment for the adjournment. It was a short period of time because today and yesterday I'm particularly unwell. So it was not 2 months. I was looking at perhaps a week or 2 weeks so that I could prepare better, and when I'm well, an adjournment application. So it was never 3 months for the application to adjourn. So I don't know if that makes any difference.
No, I think we want to hear your substantive application today.
Okay, but that brings me, before I go on to that, to what Mr. Postman has said. Now, one of the problems in this case has been because of the illegal acts of the claimant and its solicitors. I've been unable to attend any court whatsoever. This is the first time I've been able to speak at length in any survived court over the last nearly 4 years. And that statistic should make everybody see how extraordinary this case is. That's important because what Mr. Bodmer has said now, and what Mr. Bodmer has said before, and what Mr. Dugan has said in various witness statements and affidavits, are often quite simply put lies. Now, in my application to adjourn, I already set out, as well as at the time, some examples of how Mr. Bodmer has lied to the court and harassed me on social media. I set out in that application, and I also wrote to the court the last time the claimant incorrectly accused me of being in a different country. At that time, which I believe was about a week ago, they wrote to the court with a definitive statement suggesting it was fact that I was in Cambodia and I flew there first class. Both were simply untrue and made up. Now, we move on to the lawyers looking at my Instagram account again. I know full well they look at my Instagram account. All that the citizen appears to do is write me letters about it. Today, I posted a task for an invitation to speak in Geneva at a human rights conference in a couple of weeks' time. I have declined that invitation because I am unwell. Mr. Bodmer told the court a few months ago categorically that I was in Geneva, that I was speaking. This is simply untrue. And Mr. Bodmer will be aware that his duty to the court is not mislead me. So it would be interesting to understand from Mr. Bodmer how he and his historians will repeatedly state untruths to the court in the hope that some of the mud they throw stick. So I want to address that point because it's one of the salient points throughout this case where the claimant's lawyers have basically continually got away with lying, again and again and again, to the court on the basis that I had not been there to defend myself, or, as in the case today, I am not well enough to defend myself. So, I wanted to make that point very clearly. Now, in relation to my application to adjourn, the adjournment application, that was not for 3 months, that was for a week or two, because today I'm feeling exceptionally unwell, and I'm feeling unwell as I speak now. If I'm being forced against medical advice and in contravention of the United Nations Declaration on Human Rights to endure suffering and inhumane treatment in the pain that I am suffering now and the emotional stress that I am suffering now, while in the support court, then that should be noted that I am being forced to do that. I say forced because I have 2 options. I either give in and let the claimants ruin my life, take everything that I have, without any trial ever, or any examination of evidence ever, and having then put in place the most despicable deceit and lie possible that resulted in a British citizen being tortured. So they would get away with that, or I push on and I suffer. So I have a very difficult choice to make. Which one do I do? And so I think, I need to take some time now, because I'm feeling quite sick and quite well. So if I could begin a journey for a moment.
So have you finished, Mr. Haigh?
No, I just finished what I just said to Judith, I'm feeling quite sick, so I only use the bathroom.
So do you want to have a break to go to the bathroom?
Yeah, I need to go rather rapidly.
5 minutes? Okay. 5 minutes? We'll break for now, Mr. Haigh. We'll contact you again.
Okay.
All rise.
If we're not here, we're
I'm
outside.
going to keep these 2 phones connected just to save us
No, no,
time.
if we're not here, we're outside.
Hello?
Hi, can you hear me? Hello?
Hello?
Can you hear me?
Hello?
Yes, Mr. Haigh, can you hear me? Hello?
Hello?
Yes, hello?
Hello?
Can you hear me? Hello? Mr. Haigh, can you hear me? This is Lima.
Yes, I can hear you.
Okay, great. I'm just going to bring the judges back in. Sorry?
Let's do that.
Ready? Yeah, it's just yes. All right. Mr. Haigh, can you hear me?
Yeah.
Please resume, Mr. Haigh. We are now discussing the question of whether or not we should postpone the hearing of the appeal itself. You want this hearing adjourned for 3 months. The appeal hearing itself.
At this point, let me just say that I am feeling very nauseous at the moment, so again, I have to go. I'll try my best.
But
not to,
yeah, but actually we've got the thrust of your comments anyway. In your presentation this morning, you made a lot of remarks which are of general application. I think we understand your position quite well. So it's just some additional remarks, if you like.
No, I Chief Justice, I would like to. I think it's important. At the outset, though, I would like to say that I do believe, because I'm essentially being forced to carry on, that Article 5 and 10 of the UN Universal Declaration on Human Rights has been breached by the court. So I'd like that noted. because obviously I'm entitled to a fair and public hearing, and I don't feel that forcing someone to continue a hearing when there is significant legal evidence before that court is fair. In any event, that is what we are. My point in relation to why I would like to adjourn the appeal hearing are as follows. Now, I will try and not duplicate what I have said before or go into too much detail where it is covered in the written statement. But especially, linked with what I just said, is the right to a fair trial. Now, I am, as I've mentioned, well, and 6 days ago, officially became, or 2 days ago, 6 working days perhaps, officially became a litigating person, which was not expected. I therefore am unable to present the argument for the appeal properly, and I don't have solicitors, albeit I have the money to pay them, and I haven't had the opportunity to prepare the appeal. Further, I asked the Supreme Court, as per their invite, that I be able to attend court in person so that I am not disadvantaged in any way should the hearing go ahead. Sitting at the end of the phone, thousands of miles away, is undoubtedly a great advantage. I also asked the DIC court for them to facilitate a video link, and as I mentioned earlier and touched on by Mr. Bogner, I asked the claimants to agree to release my personal monies to enable me to do those things. After a filibustering response from them, they declined. Not declined, but they failed to answer me. So, at the outset, I don't think this is a fair hearing. I haven't been allowed to come to the court. I haven't been able to come via a video link, and I've now been forced, in the illness that I am, to carry on over a phone. In addition to that, the claimants are in possession of my notice of change, and they have not served on me, in accordance with that notice of change, their full statements and documents. So I do not have hard copies of those statements and documents, something that I've been asking for in terms of general documents from them for many months. So I don't have the full package in front of me of what their case is to argue. So I haven't been to court, I'm not allowed to go to court, and I don't have the documents. Now, one of the reasons that I'd ask, so before I go to that is my point on jurisdiction, and before I go into any argument for substantive reasons, I want to make a point on jurisdiction that I do not accept with respect to the DIC that it has jurisdiction in this matter. And I set this out in each and every one of the letters that I've written to the court since 2014, as have my lawyers in documents. The Dubai court, upon judgment in a criminal matter, referred to the matter and gave a temporary civil damages award and passed the matter to their sister Dubai court. It did not pass it to the DIC court. There is, as we speak, a temporary judgment, temporary civil judgment against me in the Dubai court. Now, I saw that at a previous hearing, Mr. Bogner had again, as he did earlier just now, misstated facts to the court, saying that the matter was closed, that it wasn't referred to the Dubai court, that there wasn't a civil hearing, and that it was referred to the DIC court. That is not true. And I want to make a point at the outset here that as the DIC court is of the Dubai court, it would assume to me to be perfectly simple to get clarity on that very important point. Because to continue in any application or case where the claimant has issued two of the same claims in two civil courts is an abusive process. And this is one of the examples of how the claimant has got away with saying what they want because I haven't been at hearings to turn up. So that is a point that I want to make, and I don't know if the court wants to address that now or if they just want me to carry on.
Carry on.
Thank you. Now my statement, which I've written, I think sets out in full detail, and we've discussed it already, so I won't go over it again, but it sets out in full detail the medical condition with our own, I requested the German application. And if the court wishes me to summarise them, I won't. I think they're very, very clear, and there is a significant amount of evidence for them. What I would ask the court to do, however, is to provide reasonable adjustment at this stage to the requirements I may have, which they have done today. This includes breaking for adjournment so that I can go to the bathroom to be ill. Now, in terms of my application, I set out several things that I want in addition to the adjournment. First, obviously, is my application to adjourn for a period of up to 3 months. Now, that to me can be anywhere from 2 to 3 months. And how I've come to that calculation is that I hope that my initial care and community treatment that I've had since leaving hospital will be finished as well, not indicated, but that's why I have 3 months unfit to work certificate in approximately a little bit more than 6 weeks. Therefore, I added the 6 weeks to a rough estimate of time it would take me to find barristers post that 6 weeks and solicitors, and then added some time for them to be able to review, redraft, resubmit a full skeleton argument for an appeal, and then argue that appeal together with for the pending application in the English High Courts to release funds to pay them. I also asked for various consent to adduce new evidence. My solicitors earlier in the year made an application to adduce new evidence. The application, I believe, was made in April, and neither the solicitors nor I had any response from the DIC to the application. The solicitors were waiting for that response, as I set out in my application, to expand on and waiting for additional funds to write more detailed statements from the witnesses that I set out in that application to adduce evidence. Now, in that application, as I mentioned, I omitted one of the witnesses that I wanted to adduce new evidence, and this was done because I was ill and very forgetful at the time. That person was mentioned in the English court, as I said. So that is the other application that I made in the German application. I then go on to ask that to save costs and travel, that hearing be held in London, bearing in mind that all parties are in London, save for, well, all the lawyers are in London. It seems to me more sensible. But that if it isn't in London, that I be entitled, I'll be allowed to use my frozen funds, specifically allowed to use my frozen funds to pay for a ticket, or alternatively to pay for the cost of a video conferencing so that I wasn't prejudiced. I then asked in the same order, but haven't gone on to detail why I wanted it due to lack of time, that the appeals that were marked there, these were the appeals to the Steele judgments, were put back in place, because this is, as I said, another example of how I'd be prevented from having any hearing whatsoever. And as you know, these appeals was to be held whilst I was in hospital and couldn't attend to them. I then asked for some other things which are written, and I will not go into them here. Now, I want to explain to the court the timing of the application in two senses. First, I said earlier why it arrived late yesterday. Now, in terms of why it arrived a few days before, in any event, was because in June, when my solicitors were working, they wrote to the ISC court and queried the process for payment of their bill and various other matters to ascertain additional funds from pro bono account or otherwise to ensure that I was able to release funds as set down by the Chief Justice in his order to allocate the 130,000. That was 3.5 months ago. After 2 months of being repeatedly ignored by the DISC, the DISC finally responded, with the final response being received only 6 working days before the actual appeal hearing, meaning that with 6 days before the appeal hearing, I essentially lost solicitors and barristers that were due to argue this. Now, my point here is that this could have been done 3.5 months ago, and had it been done 3.5 months ago, there would unlikely be an application to it, because we would have hoped that matters could have moved on, and I would be able to re-instruct counsel, and I would have been able to make an application to the DIC court to release funds to pay for those solicitors. That didn't happen, and I believe it's remarkably unfair and just to proceed with an appeal hearing when I'm granted no time whatsoever to deal with that certainty and bundle and response because of the ignoring of very simple requests by my solicitors from the court. Now, moving on from that, the reasons why I need to adjourn is, as I have already set out, that it was made, as far as my solicitors and legal duty counsel, abundantly clear that money released from the pro bono account, which was 130,000, would be used for a skeleton argument and a bundle. And a skeleton argument and a bundle was provided, and a letter indicating how much additional funds required was sent to the court. Now, understandably, from the various different judgments of the Court of Appeals and Chief Justice, everybody was under the impression that additional funds, whether they be from my present funds or from the pro bono account, would be permitted, and time would be permitted to make an application in the event it wasn't from the pro bono account. We were all shocked when the DISC, in a letter and not an order amending the order, then suddenly said that the 130,000 was the whole of the appeal, which clearly it isn't sufficient to do that, not least when we include VAT and other such taxes payable in England. And the result of that was that my lawyer had no option whatsoever but to come off the record 6 days before, over clear confusion over payment of 130,000, which could have been easily resolved 3.5 months before. Now, the Chief Justice has spoken previously in the judgments about one of the reasons this appeal being the fairness, or the apparent fairness in the media of the DIC court justice system in my case. And it seems to me that what I've explained there is one example of why I'm being denied justice in the event that the adjournment is not granted to me. Now I'll just go through briefly the heads of the reasons for adjournment to make sure that I've covered everything that I want to, and I apologise if there is any repetition. As I've mentioned, I've taken quite a lot of tablets and I'm quite not well. So I've already mentioned that I want to attend a hearing either by video or in person, and that obviously hasn't happened. And for me, an appeal hearing, as I've said before, is very important to me because it is the only time I've ever been allowed to come to this court, whether it was the claimant's actions that stopped me or the divine courts that wouldn't bring me. I've never been able to speak to this court before. And for me, the first time that I speak to the court substantively, I of course want to have lawyers who've had time to look at the arguments and have the resources to look at the documents properly. Now, the skeleton argument that was filed in April is unfinished. It is a provisional argument of which the court is aware because it asked the solicitors at the time to submit their final arguments. It's a provisional argument for several reasons. Firstly, because the application to reduce new evidence apparently vanished. So my solicitors at the time did not know whether they could plead the new evidence and discuss new evidence in those applications or not, and did not know whether or not it was prudent to get more detailed statements from those witnesses. None of that was done because the court did not respond and still has not responded to the application of April. That is one reason why the document was provisional. The other is that I was in hospital for the vast majority of the time from when the application was when the skeleton argument, the original skeleton argument was in April until August. Therefore, I have had very little time, not any at all, to speak with the solicitors. And similarly, in terms of financing, there wasn't enough finance available to enable me to spend a lot of time with the solicitor. The skeleton argument is not in a final form and is far from the final form. So being forced to enter an appeal with a document that is half-baked is again, I believe, unjust. Now, as I've mentioned, I want to have lawyers to assist me in the presentation and finalisation of my appeal. I'll explain to the court why that is important to me. I have two active briefs, one in Dubai and one in UK, albeit the one in the UK is subject to an application to strike it out on the grounds of unfair failure of full and frank disclosure. Those active briefs permit me to use my assets to pay for reasonable legal fees. The claimant has sought every opportunity to prevent me from having reasonable legal fees. There is before the court in England an application that I can still have to pay the lawyers, and my intention is that I would want to put an application to the DIT court of a similar fashion that I can use these assets to pay my lawyers, so that I can have lawyers at the appeal to represent me whilst I am ill. Now, I also mentioned my statement, but I won't touch on it in great detail, but one of the reasons why there has been wholly insufficient for me to prepare as a litigating person, of course there is the 6 statement that I made before, there is the illness that I've had and continue to have that the court is well aware of, but then there are the litigation tactics of the claimant and the non-stop and countless vexatious letters that we get from the claimant, which has included sending pictures of myself to me stating I look well, sending letters asking me what insurance policy my former barrister has, and as we've seen today, hounding, or rather taking photos from my Instagram, writing letters to the court that are full of lies, that need to be responded to. So all I've effectively done these last few weeks is deal with such messages and emails and spend time on drafting an application to adjourn. I spent no time whatsoever on the appeal application. Now, because that I've had no time, and because of the fact that I have not been served in accordance with the RPC, the full skeleton arguments of the claim, I have not had time to review in full or in any detail the full skeleton argument of the claims, and there are sections of it, particularly in the schedules, that I haven't reviewed at all. And again, this is purely because of lack of time. And as I've said out in my statement, but I wanted to touch on, it's very important to me to have had sufficient time, or to have had lawyers to assist me in not just drafting the final appeal, but also in responding to the points of Mr. Wagner and Mr. Dugans. Again, as I set out earlier today, and as we saw when Mr. Wagner rather, wrongly accused me of being in Geneva, and I in fact in Cornwall, near Land's End, is that in also the skeleton argument they have put forward, there are numerous statements that are dishonest and are lies, and it is imperative that I correct them, because I've been prevented from correcting them for 3.5 years. Now, one of the major points that has been mentioned, and I touched on it briefly, but I'll touch on it now, that shows the importance of me to have sufficient time to go through the skeleton argument and prepare a proper skeleton argument for myself, are these misstatements. One of those misstatements is that I never mentioned to the DIC court, or anybody for that matter, this is the accusation of Mr. Dugans, before I was released in March. And I set out in my statement clearly numerous occasions and letters that were sent to the DIC court that he stated that I was tortured. And I set those out from May 2015 until August 2016, which was the last day that I was allowed to send any documents out. And there are repeated examples of my complaints about torture, the torture of me, the complaints about the abuse of me, complaints about how I was unwell, physical effects, including damage to my wrist, my eyes, my stomach, my teeth. I requested the court inquire into what is happening, investigate, and to send someone down. And Mr. Dugans has said throughout these proceedings, and specifically in his skeleton argument, that I never, these are his words, or summarizing his words, that I've never mentioned torture before. Yet presumably these are letters that I sent to the court. He has a copy of them. And if he does so, whilst at the same time telling the court as fact that I never mentioned this before, then that's clearly very concerning. But that is just one example of many that lies, and I use that word correctly, of Mr. Dugans, that he's correcting if I were given sufficient time to go through an appeal. Now finally, for me, the appeal is incredibly important because I've been prevented at all times in the Bible of the IC from defending myself. It is clear to everyone what the plan, the illegal plan of the claimant was, and so far, no one stopped them from achieving that goal. And unless the court allows me to argue my appeal correctly, it will set a precedent whereby unscrupulous lawyers and claimants and human traffic and or kidnap opponents to jurisdictions like Dubai and other similar jurisdictions where they know they can have influence over the judicial system, the criminal judicial system, as a litigation tactic. And that is something which I doubt anyone would want to see happen. And it is therefore critical that I'm allowed to present my defence fully. So that would be to start by filing an amended defence and to engage in a full trial and a full hearing, and not to have very serious matters of allegations of fraud and embezzlement for a significant amount of money not even heard properly, and to have none of my witnesses who are all there, and in this case, to the great number of very senior members of the claimant's group of staff, all corroborate my story. For them and me to be silent before we even get to trial is wrong, and that is why the appeal to me is important, and that is why, because of the appeal, why I believe it is only fair to adjourn for a period of between 2 and 3 months to allow time to instruct solicitors so that the appeal can be presented properly and without the difficulties and disablement that I have in presenting that appeal. I'll conclude there. Thank you very much for listening.
Thank you. Now, I think we have sufficient arguments on the adjournment proper. So where do you want to go from here in the remaining 10 minutes of this afternoon? Perhaps what we should do is actually, sorry. Okay. I think what we should do is for the tribunal. I'm sorry, Mr. Haigh, the tribunal and the panel is of the court is about to retire to consider its decision on this application. Right? So if you will stay within hail, we will get back to you shortly. So,
okay, thank you.
Yeah, please stay close to your phone, and the same goes for Brian Kay. Thank you.
All rise.
Shall we?
I'm sorry, I didn't mean to do. You need to put your hand up. It happened too quickly, sorry. It all came out so quickly.
Oops, they're not here. Oh, sorry.
I was just going to say, it's cold outside. Hello?
Yeah,
Can you hear me?
I can.
Okay, I'm just going to bring the Court of Appeal back in. All rise.
Mr. Haigh, are you now on the phone? Yes.
Yeah, but
And the counsel for the claimants are back in the room. Tribunal has considered the arguments on Mr. Haigh's substantive application for adjournment of the hearing of this appeal. It is decided to dismiss that application. We are therefore going to proceed to hear the appeal, which will obviously take place tomorrow. Now, let me tell you of a new development. I've been inquiring today about the possibility of having Mr. Haigh participate in the appeal hearing via video conference. We have a new technology recently installed in the court. It was meant actually for the small claims tribunal cases, but I'm told by my IT department, I can't vouch for it, that it should be possible to use that within the main courtroom. This could be tested in the early part of the morning tomorrow, because tomorrow we have a slightly later start. We will start tomorrow at 10:30 because I need to go out for another meeting with another government department. I will finish that meeting at 10, so hopefully I'll be back here by 10:30, and then we will start. So in the earlier part of the morning, there can be some tests on the video conferencing to ensure that if Mr. Haigh has his computer and gives us whatever the details our IT department wants from him, we will try and experiment with getting through. In fact, we could do that now, can't we, Nima? Yeah. So we could try, hooking up with Mr. Haigh. So the program for tomorrow would then be that the appeal proper will take place. So Mr. Haigh, you will go first in the usual course of events. We will start at 10:30 Dubai time. I'm afraid it's a slightly early start for you again, but that's the program for tomorrow.
May I address?
That is Mr. Haigh, could we hear from you, please?
Sorry, yeah, is it something in relation to... I didn't understand. Sorry.
Which part did you not hear properly? We have made our decision that we will not grant you this adjournment that you have asked for. We are therefore going to start the appeal hearing tomorrow morning. We are hoping to be able to connect you by video conference so that you can see us and we can see you. We will start at 10:30 tomorrow morning. When we arise today, our IT department will be trying to connect with you to ensure that we can get this video conference link going. Okay?
Okay.
So now I believe Mr. Bodma wants to say something. I'll switch off my phone. Yes, Mr. Bodma.
Yes, Your Honours, if I may, I said I would perhaps take 2 minutes at the start of the appeal, if nothing else to assist Mr. Haigh, and it may assist him in marshalling his thoughts and submissions overnight. As I understand the court's preliminary view, as expressed in before Mr. Haigh made his adjournment application, you're of the view that there is another compelling reason for the case to be tried, on the grounds that there is an allegation of fraud made against Mr. Haigh, with the various other ways in which that's expressed, that there are contested issues of fact between the parties, and that Mr. Haigh should have the opportunity to test GFH's evidence and call his own witnesses. Furthermore, the indication is that the logistical and other difficulties which have bedeviled this case, and other circumstances referred to in earlier judgments, have to be taken into account. That by taking the course which the court proposed, all of the various applications made by Mr. Haigh and the substantive appeal become moot, and that the court could see no prejudice or no real prejudice to GFH in taking such a course. That was the preliminary indication from the court, for which we're very grateful, as to why it might be appropriate to allow this appeal and simply get on with listing a trial. Now, of course, I will address the court on all of those points tomorrow, but before we rise, perhaps, as I understand the court's indication, those are the areas on which they would find it most helpful for Mr. Haigh to focus to, rather than his wider allegations of global corruption and the like. It is, of course, for Mr. Haigh to make his appeal as he sees fit, but if I understand the court's indication correctly, a focus on those issues would be the most helpful. And I hope in that way I've discharged my duty as well, as a litigant person.
Mr. Haigh, Mr. Bodma has just made some remarks about what he thinks you might find helpful to address. The court makes no comments on it. You've heard me say why the Court of Appeal had formed a tentative view that they were inclined to allow your appeal for the reasons which were correctly summarized by Mr. Bodma. So you can take that aboard and address us how you will. So because we have tomorrow, I need to tell you that we need to split the day up into two to be fair to both parties. I will have to leave the court because I'm catching a plane. So I need to leave shortly after 4:30 p.m. We can take a short lunch break. As I said, we're starting at 10:30. So, Mr. Haigh, if you're going to address us tomorrow, then 10:30 to lunchtime, let's say 1 p.m., and then we'll take a short lunch break of an hour, and 2 to 4:30, roughly, that's about right, isn't it? 2.5 hours each. Very roughly, I think that time allocation sounds about right. Yes, please, Mr. Bodma.
I was merely going to say this. Mr. Haigh may wish to take the opportunity to reply to my submissions responding to the appeal. Perhaps if we guillotine me to 4 o'clock, and Mr. Haigh will then have half an hour to reply.
Mr. Bodma very generously made that offer. Mr. Haigh, I assume that you have no objection, so the timing will be, you will be on for the morning session, which will be as soon after 10:30 as I can get back from my other meeting. And then you run on till the end of the morning, around 1. We'll resume around 2. Mr. Bodma will confine himself to 2 hours so that you can have half an hour of reply to his submissions. And we will end at 4:30. Okay?
Yes.
Thank you very much. So we adjourn to this day, but Mr. Haigh, if you will please stay available, because we're going to try and do some testing with you, which I'll leave in the capable hands of Ms. Lima Hatem.
Of course, thank you.
Thank you. Right.
All rise.
Is it okay if I leave this as a complete mess?
You need to leave here.
Yeah? It's more of things that more making the place look untidy, because I'm literally leaving it as a mess. Yeah? Okay. Thank you. Thank you.
We got it. We do.
Well, certainly I had it.